hold a public meeting for the appeal of a GRAMA request that was denied. And we have two commissioners here. We have Commissioner Ivy and myself, Commissioner Lee. And so we will start. Number one on the agenda is to hear the appeal of Katie England regarding the denial of the Governmental Records Access Management Act, the GRAMA. Sorry, I'm going to just silence my phone while I'm... And we will, let's start. I think it's typical that we hear from Katie's side first. If you would please come up and state your name. Thank you for coming and working with the schedule and everything. I know it's been a little hard to make it all work.
Oh no, I appreciate the commission being accommodating. My name is Cynthia Love. I'm with the law firm of Parr Brown, Gee and Lovelace. I'm here on behalf of Ms. England and the Daily Herald. As we laid out in our appeal letter, Ms. England's request, we believe, was denied wrongfully under GRAMA. And in fact, the Utah Supreme Court has been abundantly clear on this issue that harassment complaints about public officials are of paramount public importance. And under the Deseret News case, that seems to be clearly controlling on the issue in this matter. More particularly under the statute, the two statutory provisions, as we laid out in the appeal letter, the two statutory provisions that the county cites don't appear to justify withholding the records in this case. In the first statutory section, which is 63G-2-30510, is the statutory provision that governs active investigations and allows the government to retain records only if the release of those records would jeopardize an investigation in some way. At this point, it's not entirely clear that there is an ongoing investigation, and in the absence of an ongoing investigation, that provision wouldn't apply at all under the controlling Utah Supreme Court precedent. If there is an ongoing investigation, we would still need some sort of reason to believe that the release of the particular records that Ms. England is seeking would in some way interfere with that investigation. And at this point, we don't have any information to suggest that that would be the case. And in the absence of that, the government has not met its burden to show that those records need to be or should be retained from the public under Section 30510. Under Section 63G-2-3022A, it's a little unclear the basis on which the government is asserting that as a reason for retaining the records. Although that provision does prohibit the release of some data about government employees, it certainly does not prohibit the release of all data about government employees. And in particular, GRAMA classifies records related to qualifications for job qualifications as public records specifically. And again, under the Deseret News case, the Utah Supreme Court has already said that harassment allegations speak directly to a public official's ability to carry out their job duties. And so it would seem to be that provision would also not prohibit the distribution of the records in this case. And finally, even if the records were properly designated as either private or protected under GRAMA, the government would still need to undertake the balancing analysis that GRAMA requires. And under that balancing analysis and the very clear directive under Deseret News, the public's right to know about allegations of misconduct directed at public officials, and in particular elected officials, is going to outweigh any interest in withholding those records. And so at this point, unless the commission has questions, I think that's our position at this stage.
Okay, thank you.
Thank you.
Commissioners, Ponesitake County Attorney's Office. So this situation, it's quite a unique situation, as you're well aware. Council has cited this Deseret News case and has stated that allegations of sexual harassment made of public officers are of paramount of public importance. That's not precisely true from what the courts the court held in that case in Deseret News. So you need to understand a little bit about what the facts going on and our facts in our situation here. First was, in the Deseret News case, that claim of sexual harassment was filed in November of 2003. The investigation was completed in February of 2004. So that's a passage of 4 months. And then the request wasn't made until July of 2004, so almost 9 months later. In that situation, in that investigative report, it was found that these allegations were substantiated. They weren't allegations anymore. It was conduct. And so the Supreme Court actually held that the public official's conduct was substantiated through the investigation, and that it was of public importance, and that should prevail over insulation of an official's sexually related conduct. So there, they had conduct. In our situation, we had allegations. We received a notice of a claim on October 30th. We didn't complete our investigation until December 4th. We received the request on November 3rd. They came right in the middle of our investigation. That's when the request came. Now, I want to talk a little bit more about subsection 10 and why we had to deny the request at the moment, because we had an ongoing investigation. As you're aware, here in the county, employees like to talk. Commissioner, you sent an email out saying that you heard rumors, and you had to address those. The employees here, they've been up in arms about the salary survey. And if we had let this get out to the public, and it was published in the paper about these allegations, we would have that same type of situation, and that would taint the investigation. It would inflame other witnesses against each other. It would allow them to corroborate their allegations. It would ruin the process. So at that moment, when we received the request, in the middle of an ongoing investigation, we had to classify it as non-public document. In moving forward now, after the completion of our investigation, GRAMA allows for the commissioners as an administrative body, the chief administrative officer, to go back. We're allowed to reclassify documents as well. Additionally, a denial of access under Section 305 and Section 202, subsection 2A, you are allowed on appeal to do the following. The chief administrative officer may, upon consideration and weighing of the various interests and public policies pertinent to the classification and disclosure or non-disclosure, order the disclosure of information properly classified as private under 302 sub 2 or protected under 305 if the interests favoring are greater than or equal to the interest favoring restriction of access. That's your call. So when I receive a request, my job is to initially classify it. Given the circumstances and the facts surrounding the situation, I classified it as protected because we had an ongoing investigation. Your job now as a chief administrative officer is to decide whether or not you want to disclose that pursuant to this. It should be also noted that a disclosure under Section 401 subsection 6, which I just read to you, requires them to, the movement here, to bear the burden of proof that such is public interest. I think that the Supreme Court case is pretty clear that this type of conduct is in the public interests. That's all I have, really. We have concerns, ongoing concerns, that any witnesses or the claimant's identity and exposure of them would be an unwarranted invasion of privacy. We've had conduct, or we've had communication from the claimant's attorney stating that she wanted on the record that it was important that this claimant's identity remain hidden from the public's eye, and there's various reasons for that. I won't go into that today, but unless you had any other questions.
I have a question.
Sure.
A question for you, and you articulated it very well, and I just want to reiterate it too, that you went through the process, and at the time when the GRAMA came in, we were in the middle of an investigation, and I think rightfully so. That denial of that seemed to be the best situation, because of what you articulated was, what was going on. We are now not in that same position. As you mentioned, the investigation is over. And as you also articulated, so it gives an opportunity for us to look at the best interest for the public at large with this, and also noted that you mentioned that privacy to a certain extent. I mean, we're asking for information there. And as I don't know if you've read through it. Have you read through
I've read through
decision?
some of it last night. Yeah.
I didn't see anything in there. Did you see anything in there in which I saw no names?
Are you referring to the actual
The decision from the
complaint itself? I think because that's what's the subject
from
of
the
this
investigation.
today. So I have read through that as well, but for the hearing today, I believe we're dealing with just the complaint filed. All complaints filed. So I don't think we're quite to that point yet.
Okay.
And in all the complaints filed, there will be proper protection given to individuals with name redaction.
Yep.
Right.
All right.
Okay.
Thank you.
Commissioners, you mind if I make a quick comment?
Sure.
On that point, I just told the claimant's attorney that I would make the representations this morning that I spoke with her. And as was mentioned, but I just want to come through on the promise that I made to the attorney yesterday. The attorney, she is concerned that the claimant's identification not be disclosed. The attorney would be here today, but she had to catch a flight, so she wasn't able to make it. Her concern is that the claimant's identity not be disclosed in order to prevent an unwarranted invasion into the claimant's privacy.
Okay.
So I'm just going to counter you a little bit on this. So I want to pick your brain on it. I feel for that. I know what that's like. But again, where do we draw the line with it? I mean, how do we balance that? I mean, I understand that, but where do we balance that?
Well, let me just give you two things to consider. Number one is that what I just mentioned, that the claimant here has a privacy interest in the claim, and not having her their identity made known in the public. That's the first issue. The second issue is, for your consideration, you probably may want to think about not disclosing the claimant's identity or any witness's identity, because you don't want to chill the factor or discourage future claimants or witnesses from speaking up in the future.
Now, you said the witnesses,
Right.
but in this case, we're talking about something different than.
Well, yeah, but just with the claims.
Okay.
Yeah, so in this situation, you might just say the claimant's identity. You wouldn't want to make a decision that would discourage or prevent a future potential victim
Right.
from speaking out. So those are two considerations that you might make
Fair enough.
to decide to at least redact information that might lead to the identification of the claimant.
One thing to note of importance here, Commissioners, is based upon case precedents in that Supreme Court case in Deseret News, that individual filed a claim in federal court, and the claims became public. She put her name out there. And so far, our claimant here wants to remain out of the public's eye. And so we have different sets of facts in considering an unwarranted invasion of privacy that's held by our claimant versus one that might be held by a respondent.
I can be sensitive to that because I certainly do not want this, any actions to promote not coming forward. And And so I can be sensitive to that. Commissioner, any
No,
thoughts?
that's absolutely. I think it's important that we protect those individuals.
Okay. Any other comments?
In light of the fact that the investigation is now over, I don't think there's any objection to redacting the name of the complainant. I'd also note that the policy of Ms. England and her organization is that they don't name victims, and so that's not a piece of information that's particularly anything that would be getting out into the public from their perspective. They have no interest in publicizing that information.
But
And GRAMA-
nevertheless, we can't release it because then even
Mhm.
if they don't do it
Even
on a
if they
policy
don't,
basis.
Certainly,
it's
right.
still publicly
Yes,
available at
and
that
I
point.
I think the point is that
Yeah.
I don't think there's no objection to redaction of that kind of personally identifiable information.
Very good, thank you.
Thank you.
All right. Any other thoughts? Okay. Seeing that, I know that, these, in a hearing like this for an appeal, we typically have 5 days to respond. I would hope, my feeling is that this is something that we could deal with today. And I'd like to deal with it today, and I'll just state it. I think it's in the public's interest to release this information, making sure that we have gone down through the proper procedures and redacting names that will release, the privacy, in the privacy interest. That's,
I'll make kind of my comment. I believe the county acted appropriately. There was a complaint that was brought forward. The county acted to independently investigate that, to ensure that that claim was viable, and protect all involved. I believe that's an important part of justice, is hearing both sides when accusations are made. I believe that was done, and that there is significant public interest in the findings of those things being made available, and in a timely manner.
so we typically don't take a motion on this or anything like that. It's just usually a decision. And so what I'm hearing, I just want to solidify it for sure that you are willing to grant the appeal.
I am willing to grant the appeal.
I am as well, with the stipulation of redacting the names that are there. All right. With that, I guess we will close the meeting.
A motion to adjourn.
And suspending the rules so that I can second, I will second that motion. All in favor, say aye.
Aye.
Aye. That's 2-0. Thank you.